Hello friends, welcome to my channel. Today we're going to deal with right to know under Article 19(1)(a) and Contempt of Court. Okay, this is part of Guwahati University syllabus, especially honors course. Towards the end of the last post, we saw the Law Commission traced the genealogy of the scandalizing the court offensed. Inasmuch as it sought to protect the standing of the judiciary to that of seditious libel. Seditious libel is this offence is defined under Article 124A of the IPC, Indian Penal Code. So the basic idea is the same. If people are allowed to criticize state institutions in derogatory terms, then they can influence their fellow citizens who, in turn, will lose respect for those institutions. Consequently, the authority of those institutions will be dismissed and they will be unable to effectively perform their functions. Okay, so do you know what is mean by contempt of court? The contempt may be of two kinds. It may be criminal contempt or civil contempt. So we need to first know the meaning of contempt, okay, before doing or going through anything. Let's see what is the meaning of contempt. So what is the meaning of contempt? The feeling that a person or a thing is worthless or beneath consideration, or it is an offense of being disobedient or disrespectful of a court of law and its officers. Okay, it is of being disobedient, or in simple words, disrespectful. But there is an act called Contempt of Courts Act, which is prevailed in the Contempt of Courts Act 1971, I think, which is important regarding Indian laws. So here you can see under section 2A of the Contempt of Courts Act 1971 defines contempt of court as civil contempt or criminal contempt. It is generally felt that the existing law relating to contempt of court is somewhat uncertain, undefined, and unsatisfactory. The jurisdiction to punish for contempt touches upon two important fundamental rights of the citizen, namely the right to personal liberty and the right to freedom of expression. So, why contempt of court? Or RTI, right to information, and contempt of court? Why these things are linked? It is linked in that way. Article 19(1)(a) provides the provisions of freedom of speech and expression. Guarantees freedom of speech and expressions, Article 19(1)(a), which is fundamental right. Freedom of speech and expressions impliedly includes freedom of press, because press is the only medium, the fourth pillar of democracy, which is important for democracy. Then freedom of not only this, freedom of press also includes the right to information is also impliedly included under Article 19(1)(a), not expressly, which is freedom of speech and expression, and freedom of speech and expression is fundamental rights. Now here, because we seek information from certain kind of authorities like government or others, so we need to consider the Contempt of Court Act 1971 or RTI and contempt of court. Okay, contempt may be of two kinds, as we have already seen, criminal and civil. So the jurisdiction to punish for contempt touches upon two important fundamental rights of the citizens, namely the right to personal liberty, Article 21, which is, and the right to freedom of expression. It was therefore considered advisable to have the entire law and the subjects scrutinized by a special committee. But why this act, Contempt of Court Act 1971, is important, or why this concept is important? Anything that curtails or impairs the freedom limits the judicial proceedings. Okay, anything that curtails or impairs the freedom of limits of the freedom, anything impairs the freedom of limits of the judicial proceedings must of necessity result in hampering of the administration of law and in interfering with the due course of justice. This necessity constitutes contempt of court. Why? Oswald defines contempt to be constituted by any conduct that tends to bring the authority and administration of law into disrespect or disregard, or to interfere with or prejudice parties or their witnesses during litigation. Okay, Halsbury defines, so this is, who is the person? Oswald. OSWALD, Oswald. These definitions are important. Oswald defines contempt to be constituted by any court that tends to bring the authority and the administration of law into disrespect or disregard, okay, or to interfere with or prejudice parties or their witnesses during litigation. Halsbury defines contempt as consisting of words spoken or written which obstructs or obstruct or tends to obstruct the administration of justice. Then comes another jurist, Black, Auger enunciated that it is contempt of court to published words which tend to bring the administration of justice into contempt, to prejudice the fair trial of any court or matters which is subject to civil or criminal proceedings, or in any way obstruct the cause of justice. So, however, in India, contempt of court is of two types. Number one, civil contempt, and number two, criminal contempt. These are basics which is given under Contempt of Court Act 1971. I have not gone through the whole provisions of this act. So, if possible, then we have to read the whole provision of this act. Only then our concept will be more cleared. Under Section 2B of the Contempt of Court Act 1971, civil contempt has been defined as willful disobedience to any judgment, decree, directions, order, writ, or other process of a court, or willful breach of an undertaking given to a court. So, what is the meaning of the civil contempt? You have to remember, civil contempt has been defined as willful disobedience to any judgment. Willful disobedience. Disobedience which is, of course, of willful nature, knowingly. He is disobedient to any judgment, decree, directions, order, writ, or other process of a court. What are the things? Judgment passed by court, decree, direction, order, writ passed in case of violation of FR, or other processes of a court, or willful breach of an undertaking given to a court. Okay, then comes, these are civil contempt. Then criminal contempt is more grave, more serious in its nature. Under Section 2C, so we have to remember sections as well, Section 2B and Section 2C. Okay, under Section 2C of the Contempt of Court Act 1971, criminal contempt has been defined as the publication. Okay, it is much like defamation or something like this. Whether by the words spoken or written, it may be spoken or it may be written, or by signs or by visible representation or otherwise, of any matter or the doing of any act whatsoever which, number one, scandalizes. These points are very important. These 3 points which is given, these 3 points are very important. Scandalizes or tends to scandalize. Whether it scandalizes or whether it has the tendency, means it tends to scandalize, or lowers or tends to lower the authority of any court. Okay. Then 2, prejudices or interferes or tends to interfere. First of all, whether it prejudices, or secondly it interferes, or it tends, means it has tendency to interfere with the due course of any judicial proceedings here. Okay, and 3, interferes or tends to interfere with, or obstructs or tends to obstruct the administration of justice in any other manner, administration of justice. Here the points are, again I'm going to read it because it's important. Scandalizes or tends to scandalize, first of all, or lowers or tends to lower the authority of any court. Authority, here the authority is concerned. 2, prejudices or interferes or tends to interfere with the due course of any judicial proceeding. Here it is, judicial proceeding. And 3, interferes or tends to interfere with, or obstructs or tends to obstruct the administration of justice. Administration of justice. The administration of justice means justice according to law, okay, in any other manner. Then comes A, High Court means the High Court of a state or union territory. This is given in Contempt of Court Act. So what is the object of the passing of Contempt of Court Act? There can be no doubt that the purpose of contempt jurisdiction is to uphold the majesty and dignity of law courts, because we need to follow law and order. We need to show at least some respect towards the judiciary and the law and order of this country. So, majesty and dignity of law courts and their image in the minds of the public is no way whittled down. If by contumacious words or writings the common man is then lead to loss his respect for the judge acting in the discharge of his judicial duties, then the confidence reposed in the courts is rudely shaken. Okay, confidence, the trust on the court is rudely shaken because of those disrespect, disobedience and disregard of the authority of courts, and the offenders needs to be punished. In essence, of law of contempt is the protector of the seat of justice more than the person sitting of the judge sitting in that seat. So it's not concerned with the the judge. It is concerned with the protector of the seat of justice more than the person sitting of the judge sitting in that seat, because the court must have an authoritative power to do justice or to interpret the status. The main function of judicial is interpretation of status. This is a different thing, of course, but of course, in order to do justice or give a decision, the court must compel others' obedience. So this is what the main thing. So how contempt of court is linked with RTI, right to information? As we already know, in India, the Right to Information Act 2005, it is governed for all kind of information. It's governed by the Right to Information Act 2005. So section Okay, Section 8(1)(b) of Right to Information Act 2005 says information which has been expressly forbidden to be punished by any court of law, information, okay, which has been expressly not impliedly forbidden to be punished by any court of law, tribunal, or disclosure which may constitute contempt of court. So what does it mean? To interpret this section, let's first break it into smaller parts. So we can say Section 8(1)(b) exempts disclosure of information. Okay, so what this does, Section 8 subsection 1 clause B exempts disclosure of information, because the right to information seeks what? Information. It's disclosure. But exempts means what? Exceptions. Number 1, which has been expressly forbidden by any court of law or tribunal. The things which is expressly forbidden by, forbidden means disallowed, that means not allowed. By whom? Any court of law or tribunal. It may be court of law or it may be tribunal. These are exempt. The information right before the petition of right to information, they cannot have access to those information, which has been expressly forbidden by the court of law or tribunal. Or 2, the disclosure of which may constitute contempt of court. Okay, that's why it is related to contempt of court. Now, how it's easy to follow them, the section that only the information which has been expressly forbidden by any court of law is exempt in the mere precedency of information of some related case before a court does not signify its exemptions. So one of the prerequisites for application of sections 8(1)(b) is an expressed order from any court of law or tribunal exempting publication of the information asked for. Okay, so what may constitute contempt of court is not defined in the RTI Act 2005. So what can we do now in this situation? So to know what constitutes contempt of court, we should look at the definitions given in sections 2A, B and C of the Contempt of Court Act 1971. So we have already read it. Let's read it again. Definition: in this act, unless the context otherwise requires. A. Contempt of court means civil contempt or criminal contempt. Okay, so it defines two categories of two kinds of contempt of court, civil or criminal. So we have already read section 2B and C. B. Civil contempt means willful disobedience to any judgment, declaring the directions or other process of a court, or willful breach of an undertaking given to a court. C. Criminal contempt means the publication, whether by words spoken or written, or by signs, or by visible representation or otherwise, of any matter or the doing of any other act whatsoever which, number 1, scandalizes or tends to scandalize. We have already read it. Or lowers or tends to lower the authority of any court. Or 2, prejudices or interferes or tend to interfere with the due course of any judicial proceeding. Or 3, interferes or tends to interference with, obstructs or tends to obstruct the administration of justice in any other manner. Okay, we have already read it. So after this, okay, so what can we do now? From the above, we can consider that for civil contempt, there should be either willful disobedience of any judgment, decree, or order, or other process of the court, or willful breach of an undertaking given to a court. While for a criminal contempt, there has to be publication. Okay, we know already. We have read many times this. So from the statute itself, backed up by the decision given by bench of CIC, we can interpret section 8 of the Right to Information Act 2005 that only those matters can be exempted from publication which may cause contempt of court, or which are expressly exempted by any court of law or tribunal. Sub judice matters. So what is this? Sub judice matters are those matters which are currently under trial and are being considered by a judge or court. In other words, we can say that a matter which is still under consideration by a court, i.e. still a subject of active litigation, is sub judice matter. So there is a case. In the case of Mr. P.K. Puri versus Ministry of Labour, Mumbai, the bench said that each court has its own rules regarding furnishing of copies of documents connected with a case pending before it to third parties. If the rules of the tribunal permits furnishing copies of that, so we need to read at least 2 case laws. If we want to write good answers in exam, so we have to pick those 2 case laws, right? So in the case of Mr. P.K. Puri versus Ministry of Labour, Mr. P.K. Puri versus Ministry of Labour, Mumbai. It is Mumbai, okay? Ministry of Labour. P.K. Puri versus Ministry of Labour, Mumbai. The bench said that each court has its own rules, okay, regarding furnishing. Each court has its own rules because they also have rule-making powers for the regulation of their own affairs. So, rules regarding furnishing of copies of documents connected with a case pending before it, and that case is connected with a case, and that case is pending before it, and whom they are going to furnish those copies to third parties. If the rules of the tribunal permit furnishing copies of the affidavits or other documents connected with this pending case, or if the rules are silent on this aspect, the documents sought for be furnished to the applicant within 15 days free of cost. So, two conditions are: if the court permits furnishing of those certain copies of affidavits or other documents, or if the court is silent on these aspects, then it shall be furnished. The documents are to be furnished to the applicant within 15 days, and the time period here is 15 days, and that is of course free of cost. However, if furnishing of the same is not permitted, the same may be communicated to the applicant quoting the relevant rules, because if it is not committed, it will come under what? Section 18(1)(b) of the Right to Information Act 2005, and it is some exempted matters which the Right to Information Act cannot interfere, or which will otherwise amount to contempt of court. In another famous case, the bans propounded that. So we have found one case. Let's revise it again. P.K. Puri, Mr. P.K. Puri versus Minister of Labour, Mumbai. It's easy to remember the decisions given by the court. For example, these words which are under the quotation, but it's hard to remember the title of the case. And even you can write this the lines which are under the quotation in your own words, but it's very important. These are something which you must remember. This you can make it in your own words, write it in your own words, but you cannot write a title in your own words. It is just factual, something not factual. In another famous case, the bench propounded that there has been a serious error by the respondents in assuming that information in respect of sub judice matters need not be disclosed. Okay, that there has been a serious error by the respondents in assuming that, it's just a mere assumption, that information in respect of sub judice means already pending in the court, matters need not be disclosed. Need not mean there's no need to be disclosed those matters. The RTI Act provides no exemptions from disclosures requirement for sub judice matters, so it is not an exemption. They can be disclosed. The only exemptions in sub judice matters is regarding what has been expressly forbidden. It is not something implied. It is expressly forbidden from disclosures by a court or a tribunal, and what may constitute contempt of court. Section 8(1)(b). Okay. The matter in present appeal does not attract this exemption. Presence of a different provisions in the Contempt Act about supply of documents in sub judice matters to a request has had no bearing on the disclosures requirement under the RTI Act. Seen purely from the standpoint of the RTI Act, the right of the appellant to access the information requested by him is unimpeachable. Okay. Later we find in the case of P.B. Bansal versus Food Corporation of India. So what was another case? Another famous case. The name of the case is not given here. So P.B. Bansal versus Food Corporation of India. P.B. Bansal versus Food Corporation of India, when the respondents denied giving the information to the appellant on the basis that the matter is sub judice by the respondent. Okay, respondent denied giving the information to the appellant on the basis that the matter is sub judice, and thus its publication is exempted. On this argument, the bench said, making the legal stand of sub judice matter clear, that matter being sub judice is not a ground to withhold or requisite information under RTI Act, unless the desired information has been expressly forbidden to be punished by published by that. So same thing is saying again in several cases. So you have to understand only those facts and the title of the case. This is P.B. Bansal versus Food Corporation. What happens? Okay, P.B. Bansal versus Food Corporation. Wait. Where's the case? Okay. This is a case. If you remember this title, you can write even these quotations as well. This lines under quotation as well. No problem. From this decision, it's clear that sub judice matters on their own don't have any stand. But information relating to any case which is sub judice, i.e. which is still in trial, which has been expressly forbidden from publication or whose publication might cause contempt of court or exempt to be provided if asked under the Right to Information Act 2005 under section 8(1)(b). That's it. So thank you. Thanks for watching. We will meet again in our next video. Please do not forget to subscribe to my channel, and you can join my Telegram group as well for my updates. So you have to click the link and you have to install Telegram. Okay, I have not made any WhatsApp group because it will cause breach of privacy. Probably I don't like doing WhatsApp, so I mostly use Telegram. Thanks for watching. Please do not forget to subscribe, share, and like, and